Yes.
I was told two things over the lunch in German. One is some of my clients can't hear me because I'm talking too quietly, which I find a little surprising, but there we are. The other is that Mr. Howells would like me to hurry up because he wants to make his part of the submissions. I'll leave it to you to decide which was predictable and which wasn't.
Well, juniors always were like that.
Not in my experience, they weren't, sir. But anyway. The heading on the next and final item is previous trusts and schemes, which is about their conduct or misconduct. Before I go specifically to the trusts and schemes, I just want to open that bracket a bit wider because the trusts and schemes, or at least these particular ones, took their lead from the Department of Health. And so it's important to know the type of person who would be in charge of the Department of Health. And so we're going to return to Edwina Curry. She was in the ministry, junior ministry. The excerpt of a letter that we're going to look at was, I think, written before she resigned or was sacked. And you'll see what she says. So this is to dear Mrs. Grindley. Can I just say, sir, we have Mrs. Grindley here, over there, a stalwart campaigner on behalf of the haemophilia cohort. Husband died as a result of infection. And she's been a regular correspondent with the inquiry, putting good questions and good issues which she wanted raised. So, 23rd of March 1987. Dear Mrs. Grindley, Mrs. Curry has asked me to thank you for your letter of 13th February about her remarks on 12th February about AIDS. She's asked me to reply. I'm sorry that you do not agree with what she said. We are very concerned about the dangers of AIDS. There is no cure or vaccine, no prospect that either will be developed for some years. The government is supporting research and funding a wide-ranging public education campaign to bring home the threat that AIDS poses to us all. It is essential that the message is put across clearly at every opportunity, that the only way to stop AIDS spreading is for all our people to behave responsibly. Mrs. Curry has asked me to thank you for your letter of 13th February about 13th February about her remarks on 12th February about age. I'm repeating myself. So it goes down to the last but one paragraph. I understand that you take particular exception to Mrs. Curry's reminder that good Christian people not catching the disease. She had in mind merely that for most people, a responsible and caring way of life should protect them and their loved ones from the threat of AIDS in the future. Thank you for taking the trouble to write about this important matter. That's an astonishing letter for a minister in the health department to write. It's grossly insulting to many groups. One gets a hint of homophobia there. It's insulting to people who don't lead a good Christian life. It suggests that if you have HIV, that maybe you don't lead a good Christian life. It suggests that this sounds positively medieval, but if you are a good Christian, that will stop you getting HIV. There's not an awful lot more for me to say about that letter. It speaks for itself, and what it says is dreadful. So put that to one side, and let's go back, if we may, to the previous trusts and schemes. Thank you, Lawrence. So this section will comment upon the purposes for which the trusts and schemes were set up, whether they supported the infected and the affected, the manner in which the trusts and schemes treated them, and the extent to which they operated in an open and fair manner. They operated along similar lines, often using the same staff, especially at a senior level. For the most part, we do not intend to consider each scheme separately. Rather, we will take an overview of the schemes, given the time that has elapsed since the closure of the old schemes, the setting up of the present schemes, and with the prospect that a wholly new compensation scheme will be devised. We make no recommendations to make on the issues arising under this particular heading. I should perhaps have added a sentence, but please make sure that no one ever behaves as badly as these people did. We have extracted from the evidence of the infected and affected of their comments about their dealings with the schemes. We also have relied upon the evidence of employees of the schemes. I'll just name them so you can see we've taken a fairly widespread view. Anne Lloyd, Nick Fish, Mark Mildred, Russell Nishgon, Susan Daniels, Anne Hithasay, and Jude Cohen, although there are others as well. We do, however, invite the inquiry to make the following findings. So no recommendations, but findings. That the purpose of creating these schemes was not to provide meaningful and appropriate support for the infected and affected. Rather, they were used by the UK government as a means of avoiding any investigation into this medical disaster, whilst at the same time appearing to provide some support to certain categories of those infected or affected. The schemes were used as a smokescreen to cover up the lack of any meaningful financial or other support. That the use of arm's-length bodies was a device by which the UK government could cover up their control of the activities of the schemes. The schemes operated as if they were an extension of the Department of Health, whilst keeping the registrants at arm's length. They didn't seek to protect the beneficiaries, rather they sought to protect the Department of Health. We then set out some examples. In any dispute regarding the beneficiaries and the Department of Health, the schemes took the side of the Department of Health. The schemes were not accountable to the beneficiaries, or at least they acted as if they weren't. Rather, they appeared to have decided that they were accountable only to the Department of Health. They declined to raise issues which might have caused embarrassment to the Department of Health. They appeared to have decided that they would not rock the boat. They refused to promote or advertise the schemes, preferring any potential applicants to find them. They refused to campaign for the infected and affected, in particular for more money from the Department of Health, or seek any public contributions. They refused to campaign for greater social and health support for the infected or affected. Those who controlled the schemes, the chair, the deputy chair, the trustees, took their lead from the Department of Health and from the civil servants that sat on the boards. They followed what they regarded as the Department of Health line. So, by way of an example, they built up reserves of money when told, they reduced the reserves of money when told, and they didn't object when told to transfer the remaining funds to the Terence Higgins Trust, even though the beneficiary of those schemes wanted the funds to be distributed to them. They didn't seek to empower the infected and affected. The agonizingly slow speed at which the various schemes developed illustrates the uncaring attitude of the UK government. We say the schemes were run in an ad hoc, careless, inefficient, bizarre, and illogical manner. So, by way of example, they employed people who, for the most part, had no previous experience of medical matters, let alone any knowledge of HIV or hepatitis. They employed people who, for the most part, had no previous experience of exercising any sort of discretion to decide whether or not an applicant should receive support or not. They employed such people without providing any induction into their roles. They appeared to have been expected to learn what they were supposed to do as they carried out their tasks. Most had little experience of financial matters. They were expected to decide whether a beneficiary should be supported by helping the person to buy their own home on a mortgage, and if so, would it be by making a grant, by a loan, by taking a mortgage on the property, or by some other means. If financed, they don't seem to have had any fixed policy as to whether it's financed by a loan or a mortgage, whether it was transferable. They made their decisions on the hoof. The beneficiaries were expected to get 2 quotations for every item or piece of work which they needed to be paid for, no matter how small. The schemers could refuse the request, might require low quotations to be obtained, or allow part of the request, but require the beneficiary to pay the balance. This process, which was not required under the terms of the trust, could cause, or would cause, maximum delay, maximum frustration, distress, and upset. There was no attempt to identify and reach out to the infected and affected to alert them that they and their family might be entitled to support. The evidence the inquiry has received in respect of widows is that they made no attempt to contact the widows because they thought that they would have known about the various schemes by keeping in contact with the haemophiliac centres after the death of their husbands. This is an absurd approach to keep in contact with the infected or affected. These are women whose husbands were, I was going to use the emotive term killed, but I use a lesser term, who were responsible for the death of their husbands. And they seem to have thought that they would remain in contact with the hospital. It's preposterous. There were no fixed criteria which would be used to decide whether an application for support should be granted. There were no secretarial resources. The applicant couldn't support their application with a statement or photograph. The applicant could not support their application with medical evidence. Often there was no forum on the scheme's websites, or if there had been one, it was shut down when people became too critical of the schemes. The applicant was not entitled to attend the meeting when their application was considered. The application was not entitled to give oral evidence. Just stopping there for one moment. They seem to have broken nearly every rule that you'd use to create a court, a tribunal, something to be heard, and where a judicial type of decision should be made. Excluded every possible avenue of contact. The receipt of blood had to be confirmed by an applicant's medical notes. It was not sufficient that the applicant or their doctor confirmed that blood was or was likely to have been used. No record was kept of the consideration of the claim. If a medical opinion was sought, then it was done on an ad hoc, informal, and unreported basis. For the most part, there was no one who could advise them on benefits. There was no regional support workers. There was no long-term plan as to how the schemes could be developed to provide support for the infected and affected. The amount of money paid was very low. The amounts paid were inconsistent between one registrant and another, notwithstanding they wanted the same item. The registrants were expected to apply for support from other sources before applying to the schemes. This wasn't a requirement in the documents setting up the schemes, it's just a rule they decided to impose. The net effect of this was that, once again, the application of the schemes was unnecessarily delayed. The applicant was not informed as to why their application had failed. The application was not informed what additional documents, if it had been provided, would have allowed the application to be successful. Whether deliberately or otherwise, those in charge of the schemes didn't try to develop or encourage a meaningful, constructive relationship with the infected or affected. On occasions, those in charge of the schemes would act in a deliberately awkward and obstructive manner, and we'll come to examples of that shortly. The schemes made no attempt to contact or in any constructive way communicate with the registrants. The schemes refused to publish any information or guidance regarding the discretionary items that could be claimed, nor the amount that would be allowed. They seem to have thought that the registrants could not be trusted, that such was their character that they would make a claim for everything they could and for the maximum amount available. They were concerned that if they published such a list, the great unwashed, as these people were described, would use it as a shopping list. What an appalling attitude to bring to the distribution of funds, even the minimum money that was available, in dealing with these applications and these badly hurt people. The approach about the question of shopping list is somewhat ironic, given the fact that the only evidence of dishonesty is that of Foster, an employee of the schemes, who carried out a wholly unsophisticated fraud by paying cheques to the value of £400,000 to himself. Despite the absence of any evidence or indeed allegation of dishonesty on the part of the infected or affected, it appears to be them who were made subject to more stringent conditions. The registrants were not invited to take part in any important meetings with the trustees or representatives of the Department of Health. There was, for the most part, no newsletter, no partnership group. Their address, and you'll remember the evidence of Mr. Peter Stevens, who we'll come to in one moment in more detail, their address was kept a secret because they didn't want unwanted callers. That's you they didn't want.
There was, for a while, a partnership group.
There was, which is why I said...
Anyway.
Yes, there was. I'm terribly sorry interrupting. There was, at various stages, which I think, why I prefaced, I hope, my remarks about, for the most part, or for most of the time.
Yes, I think that's... I wasn't quite sure whether that most of the time covered partnership group,
yes.
Because in your written submissions, it doesn't.
Yes.
But I understand the point that there wasn't one for most of the time.
Yes.
In the same vein, you say that the schemes made no attempt to contact or in any constructive way communicate with the registrants. There's some evidence, is there not, that the McFarlane Trust did have away days or weekends, at least early on, with those who were members of the scheme, and that the Eileen Trust did too.
Yes, there is evidence about the McFarlane Trust about that, although that soon petered out. The Eileen Trust is an odd body on these trusts and schemes, and there seemed to have been an element of class. That would be my next point I was going to make anyway. An element of class, because the people going to the Eileen Trust would have been perhaps middle class, perhaps working class. Those going to the other trusts and schemes would often be working class people. They would often not have very much money because they've been affected by haemophilia for many years, or they would be seeking support from the trust and not receive them.
I follow that they may have been lower income, but is it not the case that the diseases hit without reference to the class of the recipient, but across the board? It may have resulted in those who were given the infections losing a source of income which they previously enjoyed, but the actual infection didn't discriminate on a class basis, did it?
Well, there are some hints that they might have been. So if I can just go on one moment, it's the next point. It is noticeable that employees comment on the fact that a number of chairs, trustees and board members were middle-class men, well off from a professional background such as finance or from the military. And Cohen, one of the witnesses, suggests that they liked the feeling of power. A number of employees comment on their lack of empathy and sympathy because the people they were dealing with came from a different class. Make of that as you will, sir. But there's certainly more than a hint that the difference in classes between the professional middle-class men who are running the schemes dealt with working class men in particular very badly,
I
with...
understand the point about the constitution of the trust board or the company board, whichever it was. But that I do understand.
Yes.
And they may not have found it as easy to deal with people who did not share their background. That I also understand.
In which case they shouldn't have been there. If they can't deal with the people...
Yes, that's... I'm going to stop interrupting. My apologies.
Yes. Well, there we are, sir. It's a matter which is brought to our attention.
I have a submission that the board should have been more representative.
Yes. Or just behaved themselves. Behaved accordingly.
Well, I understand that point too very well.
So I'd just like to, as a last point, deal with a particular family. It's the Lewis family from Cardiff. So perhaps we can have the photograph of Mr. and Mrs. Lewis up, please. There we are. Ladies and gentlemen, this photograph's been produced before. That's Hayden Lewis with his wife. There's also a picture which we don't need to turn to, Gareth Lewis. Gareth was Hayden's brother. They lived in Cardiff. Hayden and Gareth developed HIV and hepatitis C. They had received that whilst being treated by Dr. Bloom at the University Hospital. Hayden wasn't immediately told that he had HIV, as a result of which he infected his wife. So that's Gaynor Lewis. They have 2 children. Fortunately, the children survive, and so does Mrs. Lewis. At a very early stage, particularly Hayden, but also Gareth, became involved in campaigning for the rights of the infected and affected. The prompt for that seems to have been the result of the death of a young boy in the clinic. We've had his name, Colin. And such was the distress they felt, was that they thought they should do something about it. And so the 2 of them set up the Birch Grove group in the Birch Grove pub. And that went on to the Birch Grove organisation more generally, and then I think became Tainted Blood. Although, from the descriptions we've had, Gareth was a somewhat fiery individual, Hayden was less so. Hayden has been described as a thoughtful, polite, hard-working young man. Unfortunately, because he was a campaigner, he seems to have fallen foul of Mr. Peter Stevens. Mr. Stevens, a degree from Oxford University, is obviously very clever, became a financial analyst during the course of his professional career, became a trustee on the Macfarlane Trust in, if I can read my writing, 87. He then sat on nearly every board that was dealing with dealing with support. And he ended up a director of the Skipton Fund. For reasons which are inexplicable, Mr. Stevens treated Mr. Hayden Lewis in a terrible manner. In making these remarks, I bear in mind that Mr. Stevens also suffered grievous loss in this medical disaster, with at least one son infected and one son infected who died. that makes his behaviour even more makes his behaviour that much more surprising. I want to deal with, oh, sorry, take that down. I want to deal with, it's the statement from, no, the cross-examination of Gaynor. So this is the transcript, sir, 26 July 2019, of Gaynor Lewis. She deals with a number of things, as we'll see. So, question. I think it was Miss Richards who was conducting the questioning. I just want to ask you, as the last area of questioning that I have for you about the McFarlane Trust. Hayden had a lot of dealings over the years with the McFarlane Trust. You've described them in your statement from your own perspective as terrible to deal with. An uphill battle with obstacles in the way, and Hayden was particularly concerned that they weren't providing enough financial help and support. That's right. There was one time when we moved to the house we're now in. There was work being done, a downstairs bathroom. We called them adaptations, but the McFarlane Trust would see it as renovations, and the council would pay so much towards the work. But there was £5,000 needed, and we asked, or Hayden asked, for the money, and this was bouncing back and forth for a couple of months, I think. And Fran rang one day and said, "We've got a meeting, and I'm sorry, you can't have it, the money." I burst into tears because I could see the work being done. It was boosting him and giving him something to get up for, you know. So I burst into tears, and she said, "I'll phone you back, hang on." They changed their mind just like that. What if I hadn't burst into tears? What about all those other people that just accepted? No, they were awful. So we say that was appalling behaviour. There either is a rule that they apply, and guidance that they apply, or there isn't. But they're persuaded to go one way and not the other because of whatever reasons they had for not advancing the money to Mr. Hayden Lewis, and then they change because a woman cries. As she herself said, what if she hadn't cried? They wouldn't have got the money, they'd have a building half finished. And then Miss Richards goes on, we're going to look first of all at a letter and then at some emails. The letter is 2368009, please. This is a letter, 30th of April 1996, from the McFarlane Trust. It's addressed to Dr. Dasani, and it says this. I should explain. Dr. Dasani was one of the main people in charge of the haemophilic. Only 2 more days and you can have your phone on whenever you like. Dr. Dasani was one of the main doctors in charge of the Cardiff Haemophilia Centre. It says, Dr. Dasani, your patient, shown above, has made a request to the Trust for financial assistance, which will be considered by our trustees at their meeting in 3 weeks' time. Since on present policy single payments are almost invariably health-related, the trustees have decided that the anonymous case summaries, which they receive in advance of their meeting, should contain up-to-date health information gathered in a consistent fashion. To meet this aim, where the health information held on a particular patient is older than 6 months, a doctor's report will be requested. Then there's reference to how often doctors might be asked to provide information. Then it says this, all the information contained in the completed report will be treated as given in confidence to the trust and will not be shared with the patient concerned. Gaynor, it doesn't surprise me. Were you aware the Macfarlane Trust was asking for confidential medical reports? No. Contents of which wouldn't be shared with you? No. Once again, sir, it hardly needs saying what appalling conduct. They're getting secret reports from a patient and getting the doctor to conspire in that by not telling their patient, what they're doing. Then it says, could we have it on the screen, please? 8016. Going to look at some emails between Martin Harvey, Chief Executive of the Macfarlane Trust, and Peter Stevens, Chair of, and then Gaynor intervenes. Can I just say that before we read this, the context of this is that Hayden, I didn't, get the £20,000 when the first payment and my boys didn't get the Category G payment either. So Hayden was talking to the trust. He didn't want a penny more or penny less, only what we deserved, and this is the outcome. Miss Richards, you were what the trust termed, and the inquiry was heard the phrase before in relation to other witnesses, an infected inmate. Yeah, nice. Question. We see, thank you for explaining the context, we see what the email is. So, quotations. Martin, what's with these people? Funnily enough, when you set it out, as you have done, it makes one wonder why infected intimates are treated exactly as registrants, since they do not have haemophilia to worry about. We might see if we can review that when we get round to looking at reg pay, which I'm reliably informed was the regular payments that were made at the NSSC. That would be a way of pissing off the Lewis contingent. Unbelievable, sir, that someone could write about that with one brother infected with HIV, hepatitis B, the other brother also infected, and he knew that Gaynor also had HIV. The second email we're going to look at is the second page, please. We'll just look at the top, first of all. The context shows an email from Hayden referred to a meeting he'd attended where he had lost his temper. And it's an email in which he says he was so angry and frustrated with the meeting. He was unable to make his point and get any sensible answers, and he lost his temper. And he says in the email at the top, I'd like to apologise to all present at the meeting. That's Hayden apologising. Then he says this, I ended the matter with a statement of never writing to either the chairman or the chief executive again, which is a sad conclusion to the whole matter. What I'm even sadder about is the chairman and CE don't even seem to care that one registrant has now lost all faith in the honesty and integrity of those involved, and I'm left with no way of contacting the trust with any belief of what they will tell me is true. Then further on, he adds that you will now be dealing with the trust on behalf of both of them. So that's Gaynor will be dealing with them. Then if we go down to the bottom email, please, then Miss Richards reads it out. It's from Peter Stevens to Martin Harvey. Martin, as I prepare to go to bed, I recall that I shall never have a private email from Hayden Lewis again. Oh, happy day, indeed, Kalu Kala. But I have not yet discovered if you too nurse Lewis Carroll streak. Otherwise, what a monumental waste of time. Not just this afternoon, but all the previous hours spent nurturing that load of moaners. And then there's a reference to an individual, said there are some people who want to get on with their lives However, I guess we just have to persevere. Peter. The third email that you have provided to the inquiry again is the 5th page, please. We can see again the context here is an email from Hayden to Peter Stevens. I should say that these emails are all from 2004, and it's an email in which Hayden sets out a number of matters that he's asking to be considered. We might go through the detail of that. We can see the context from the email itself. We can go to the bottom of the page, please, from Peter Stevens to Martin Harvey. Martin, notwithstanding the heading being Private Letter Chairman MFT, I thought you'd love to join me in starting the week with an insight into the thoughts of Hayden Lewis. I shall try to compose a reply in the due course of the day. I shall point out to him that I am unable to provide him with information about expenses without asking you. It's irritating that some Boyd was so thick that we came up with such meddlesome, so thick can come up with such meddlesome suggestions. He spelt somebody wrong. Yes, spelt incorrectly. Of course, sir, there is always the possibility he was going to say some boyo. We don't know. You seem puzzled at that suggestion, at that word.
You could say somebody, wasn't he?
Well, it may be. It could be just an O on the end that it would require. Take the D off and you've got some boyo.
Well, some boy or somebody so thick.
Yes.
It doesn't alter the flavour of it at all.
No. And then Miss Richards continues. So, sorry, those are 3 of the emails you shared with the inquiry. Sorry, Paul, can we go back to the document? There's just one further email I want to put up, and it's the 3rd page. It's an email from Martin Harvey. It's maybe an email to Hayden. It's not clear, because I don't think we have the full consecutive email exchanges. It's not specifically directed at. Any issues relating to Hayden. He just says this: nobody will argue with the sentiment that that whatever the amount of money available, registrants do not get sufficient financial support to recompense for what has happened to them, that each and every one of them would swap their MFT involvement for a clean bill of health. That was true, but why were they writing to each other those disgusting letters and emails? Was Hayden a bad man? Was he uncouth? Was he rude to them? Many of you will remember him. If not, we had evidence about the sort of character he was. In a moment, we're going to see an interview that was conducted with Hayden shortly before he died. When you look at it, sir, we invite you to give some thought, and I'm sure you have already, as to whether Hayden merits all the disgusting things that were said about him. We respectfully suggest he came over as a thoughtful man, a driven man, a man who wanted to put forward what was best for him, his family, and the wider family that's been affected in the way that they have. In any event, we'll have the film now, please.
An independent inquiry into how contaminated blood products were given to haemophiliacs in the UK has said it was a horrific human tragedy.
The report condemned the government's procrastination that led to around 5,000 NHS patients given blood which was contaminated with hepatitis C and HIV. It happened during the 70s and early 80s, and nearly 2,000 of the patients have since died.
We can speak now to Hayden Lewis, who was infected with HIV and hepatitis C. Hayden, just take us through what happened to you, where you are now.
Well, I've progressed from being told in 85 about the HIV, to 94 being told about the hepatitis C, to 2001 being told that I received 6 batches of implicated VCJD blood from a victim that had passed away, and then last September I get told that due to the hepatitis C, the liver is forming liver cancer and tumours are growing. So now I'm on the priority list for a transplant, basically.
Has anyone paid you any kind of compensation or accepted any kind of blame for this?
I love the way the government like to use the word compensation, because compensation implies liability has been accepted. And to date, no haemophiliac has received any compensation whatsoever. We've been drip-fed appeasement money, basically, since 1989.
Also extraordinary in just how long they have taken to respond each step of the way.
Why should it be seen extraordinary? If somebody's guilty of something, then it's going to get a positive response from government. In 1991, they conceded to a moral obligation. Now, anybody who knows anything about politics, government do not concede to any moral obligation unless they think they hold a legal one. And they conceded to a moral obligation. Lord Archer's report today is just regurgitating what was reported in 91. It's just basically the same data.
So when this report says horrific human tragedy, it does not apportion blame?
No. I think he felt very conscious of the fact that because it was an unofficial inquiry, therefore he didn't have any insurance cover to being sued for what he may or may not say, that he was very careful in the words he chose. But certainly it's been a horrific sequence of events, but tragedy and disaster imply accident. I don't perceive it was ever an accident.
Tell us about your family and the sort of ramification it has had on all of you.
It's had a profound effect on me, as far as it's taken away my complete control over providing for my family. I've had to rely on the whim of government giving me charity handouts for the past 15 years, since work was just unattainable for me to continue. I mean, I'm a qualified carpenter, and that should suggest, why would a haemophiliac become a carpenter if he was really worried about cutting himself and bleeding to death? That is the whole point here. All the products that came from America were brought into this country under the premise that they were life support therapies, meaning if we didn't receive them, we would die. Incorrect. But to get them through the process of vetting, they have to be deemed as life support therapy.
You chart something that has gone on for decades now. We were talking about that, this all having started in the 70s and 80s. I mean,
1971, basically.
Yeah. Well, so however many years that is, 36, 37.
Yeah.
What should happen now?
I think government should swallow their pride and take their medicine and say they're sorry and deal with this properly. If they don't want to concede to any legal liability, that doesn't mean to say they can't address the matter from a legal perspective.
Because we have arrived at a point where still nothing has been sorted. I mean, in the last 2 years, you said another 30 sufferers
Another 30
have
have died since Archer
So
started
every
delivering.
year that this happens is another family.
The death rates now are greater than they were in 1990. And the haemophilic community is diminishing by 15 to 20 on average every year.
And I just wondered whether you see any sign of that change of heart, that kind of apology coming from the government, them taking their medicine.
I'm a very optimistic person, and without hope, then really you don't want to get out of bed in the morning. So I always hope that they will have a change of heart. I think we really need to say it as it is, because there's current ministers who are actually still in Parliament. Kenneth Clarke is one, for instance. He was health minister at the time, who remained silent. Well, I'm sorry, to remain silent in the knowledge of an injustice, to me, is, as far as I'm concerned, an accomplice to the whole tragedy.
Hayden, thanks so much for
You're
coming
welcome.
in. Thanks very much indeed.
Did you recognise yourself at the end, sir?
Yes,
There we are, so those are my submissions.
in my younger days.
Those are the end of my submissions, and Mr. Howells is now going to follow on.
So I intend to make submissions on three main issues. Firstly, the unlawfulness of the disparity that emerged in the sports schemes in the Four Nations. Secondly, the failure of the Wales office and the Northern Ireland office to achieve self-sufficiency in their respective nations. And thirdly, the conflicts of interest that impacted upon decision-making and the implementation of those decisions. Turning first of all to the unlawfulness of the disparity in the support schemes, may I preface this section with 3 points. Firstly, this really matters to our clients, and so it is important that I address you in relation to it fully. Secondly, some level of technicality is unavoidable, but I shall try and minimise that technicality. And thirdly, the ultimate point is that there should never have been different financial provision in the 4 nations, and that should never happen again. It is well known in this inquiry that when the UK government announced an uplift to the payments in the English Infected Blood Support Scheme, which I should call EBS, on the 30th of April 2019, there were no equivalent uplifts made to the payments for the support schemes in Wales and Northern Ireland. The difference in payments was not insignificant. That position was allowed to continue until the 25th of March 2021, when finally the 4 nations reached agreement on what parity meant across the 4 schemes, and Her Majesty's Treasury provided funding to the governments of Wales and Northern Ireland so that the payments made by their schemes were increased. So for a period of almost 2 years, the UK government allowed a position to continue whereby the infected and affected who lived in Wales and Northern Ireland were treated differently to those who lived in England. For 2 years, during the currency of this inquiry, the UK government exacerbated the resentment and mistrust felt by many, if not all, of our clients who reside in those countries. This was at a time when the healing process brought about by this inquiry should have been taking place. Let it not be thought that the only real effect on our clients was financial disadvantage. No. The utterly inexplicable difference in treatment caused an increased sense of injustice and a feeling that not only did the UK government not care about them in the 1970s and the 1980s, but that it did not care about them now. Lawrence, please can I ask for WITN 450 6014. This is a letter from Dr. Kofi, who is a consultant clinical psychologist based at the Wales Infected Blood Support Scheme, which I shall call WIBS. And it's to the Welsh Government, dated the 11th of March 2021. And if I could start with the second paragraph, please. And Dr. Kofi says this: "It is crucial that the context and impact of the decisions of a higher powered organisation are seen as relevant and need consideration. There are similarities between the decisions of the governments now and the NHS then, which is a reminder of the harm, not help, that was inflicted upon the beneficiaries. Understandably, people report entrenched feelings of anger and injustice, alongside damaged identities related to feeling like a second-class citizen, as unworthy and undeserving, due to a growing awareness that harm was knowingly inflicted on an unimportant group of people. The extent of the psychological injury is unquestionable. The acceptance and normalisation of the harm caused is only more recently being exposed and challenged, but the current legitimisation of the lack of parity is a highly sensitive reminder that again such people are targeted as less than, causing secondary psychological injury. The inequality provokes reactivation and reliving of past traumatic experiences and can be perceived as confirmation that fairness is not required due to the second-class citizen status. Equality and fairness would help to interrupt the trauma cycle and the associated symptoms, providing a platform for the complex journey towards adjustment and acceptance of situations of harm and injustice. Achieving parity would demonstrate the importance of recognising the need for fairness and justice, and I've been struck by the resourcefulness and resilience shown by the beneficiaries of the scheme, and surprised by the desire to move forward from such painful experiences. Realistically, the associated traumas will never be resolved, but it is psychologically damaging and limiting progress if aspects of inequality, in particular the lack of financial parity across the 4 devolved schemes, are not currently addressed. The disparity in payments should never have been allowed to happen. The suggestion that the schemes were established by each of the 4 nations to respect the devolution settlements is, we say, a fallacy. The truth of the matter is that they are the unfortunate consequence of flawed and opportunistic decision-making by the UK government. The original plan in 2016, when the UK government first started drawing up consultation plans, was that there would be a UK-wide scheme. The reference for that, sir, is WITN 4688013. We now know that as a result of the Scottish Government making a unilateral decision to establish its own scheme, the UK Government reacted by establishing EBS, without further discussion with the governments of Wales and Northern Ireland. And I invite you, sir, to see in particular the evidence of William Vanille, a senior civil servant in the DHSC, who gave evidence alongside Matt Hancock at page 108 of the transcript, and also document WITN 4066007 at pages 3 and 4. That this was the situation was confirmed by Vaughan Gething, who was then the Welsh Minister of Health and Social Services, who admitted that the Welsh Government reacted to the decision of the UK Government and set up WIBS out of necessity. And I invite you to see pages 8 and 9 of the transcript of his evidence. So the schemes in the four nations were not the result of a conscious decision that that is what devolution demanded. The result is a curious dichotomy in the approach to those infected with HIV and to those infected with hepatitis C. The UK government has always accepted its responsibility to fund HIV payments, and it continued to do so by way of a budget transfer to the governments of Wales and Northern Ireland. And the references for that are WITN 4065004 at paragraph 12 and DHSC 303814 _090 at paragraph 37. But the UK government takes the view that the governments of Wales and Northern Ireland are financially responsible for hepatitis C payments because these were established after devolution. That is to say, that the first devolution settlement took place in 1998 and the Skipton Fund was established in 2004. It is incongruous that there should be a difference in the identity of the government with financial responsibility for payments for each of HIV and hepatitis C, when both viruses were transmitted in blood and blood products at a time long before the devolved governments were established. It is frankly illogical to say that the devolved governments have competence to make hepatitis C payments, but do not have competence to make HIV payments. WIBS was given statutory powers to make payments to eligible persons by the Wales Infected Blood Support Scheme No. 2 Directions 2017. Those directions were made under the National Health Service Wales Act 2006, which is an act of the UK Parliament. If that act gave the Welsh ministers a power to make payments to infected persons through WIBS, there is no proper basis for saying that it did so only in relation to hepatitis C and not HIV. That is because the exercise of the power under that act was not conditioned by devolved competence. It was a statutory function given to the Welsh ministers by an act of the UK Parliament. The inquiry has heard evidence that in 2002 a dispute arose between the UK government and the Scottish government about whether the Scottish government can make payments for hepatitis C. And the reference for the email raising the dispute is DHSC 0042275 _129. And that was an internal email to Charles Lister in November. And that resulted in a joint advice from the UK and Scottish law officers. So may I bring that on screen, Lawrence? It's DHSC 0042275 _012. If I could just have the summary to begin. So the summary says, in summary, the law officers consider that the Scottish Executive's proposed scheme for payments to persons infected with hepatitis C as a result of treatment by the NHS in Scotland would be within devolved competence. So that's the law officers saying Scotland can set up this scheme if they want to. And then, Lawrence, could we go to paragraph 3 on page 2? At paragraph 3, the law officers set out the features of the scheme proposed by the Scottish Government, and, sir, I would draw your attention to the last bullet point. that what was being proposed was no payments are to be made to dependents of infected patients. And I say that's important to understand the advice going forward. And then, Lawrence, paragraph 16 at page 4. So ultimately, this is the reasoning given by the law officers as to why it was within devolved competence of the Scottish Government. In this instant, the law officers consider that sufficient additional factors exist to indicate that what has been proposed by the Scottish Executive differs in purpose from the scheme for financial assistance for social security purposes. The Scottish Executive scheme has the stated purpose of providing compensation to a particular class of individuals who have suffered injury through a particular source. These people are to qualify for payment not on the basis of being sufferers of hepatitis C, but rather where it can be shown that they have been affected by that virus, and this has been caused by NHS treatment in Scotland, an agency of the state for which the Scottish Executive is responsible. That infection, so caused, is proposed to be treated as an injury for which compensation should be paid on a no-fault basis. It is understood that the concept and function of compensation in this context would be broader than that of damages, the latter being more calculated to respond to the degree of loss suffered in any particular instance. So that's the reasoning. And then, Lawrence, paragraph 22 on page 5, please. The law officers were obviously aware of the HIV payments, and this is what they say about it. At the same time, the law officers recognise that there will be a need to maintain a consistent and coherent approach to other payment schemes in the assessment of whether they fall within devolved competence or reserve competence. For instance, the law officers are aware that schemes for the payment of those infected with HIV virus through treatment by the NHS have been dealt with as schemes for social security purposes. I pause there to interject that that would therefore mean it's not within devolved competence. It is understood that the trusts which operate those schemes have been paid entirely from funds from the UK government, including in the period after devolution. Yet if the driving purpose behind these schemes has also been the provision of compensation to persons who have been injured through HIV infection caused by the NHS, i.e. not simply sufferers of HIV, there may be nothing to distinguish that purpose from what is proposed by the Scottish Executive in relation to hepatitis C. The law officers do not attempt to resolve this particular issue, but see that it raises questions of this kind. They observe that it might also be possible to distinguish such a scheme from that applicable to those infected with VCJD. If the basis of payment to such sufferers is simply infection with that illness from whatever source, but they express no view. That leads to this submission, sir, that it may be that the UK government formed the view in 2004, which is a view they still hold, that it was not responsible for hepatitis C payments across the UK based on this advice. If so, if they took that view, then it is wrong for 3 reasons. Firstly, the law officers were specifically advising about a compensation payment to an injured person which did not involve payments to dependents. The Skipton Fund, conversely, did make payments to dependents and contained discretionary elements based on need. Secondly, the law officers specifically identified that HIV payments had been treated as relating to social security, and it was hard to distinguish between the two. And thirdly, this advice relates to the Scotland Act 1998, which from the outset of devolution empowered the Scottish Parliament to legislate on all matters save for reserved matters. That was different to the form of devolution that existed in Wales at that time, and so the advice could not be read across to Wales. We have provided the inquiry with a note on the phases of devolution in Wales to assist with an understanding of that difference. Jane Hutt, the first Welsh Minister for Health and Social Services between 1999 and 2005, confirms as much in her witness statement at paragraph 35. And the reference is WRTN 7293001. To conclude in this segment, sir, there are 2 submissions that we make. Firstly, the UK government, from the moment it unilaterally decided to increase payments made by EBS, without providing funding to the other support schemes, acted in a way that discriminated on the grounds of nationality. It always accepted that it was responsible for making HIV payments, but it paid more to those who lived in England than the rest of the United Kingdom. that was a wholly unjustifiable difference in treatment. Secondly, the UK government acted in an underhanded way in making the announcement it did in 2019 without giving any notice to the governments of Wales and Northern Ireland, in much the same way it did in 2017 when the schemes were established. It acted in an underhanded way by stating that the increase was to be funded from the existing DHSC budget, so that there would be no consequential funding for the devolved governments. As Vaughan Gething put it, it essentially found the money down the back of the departmental sofa. It failed to do the right thing and resolve the disparity in payments for almost 2 years. As it was put by Vaughan Gething in a letter to the UK Minister for Care on the 9th of October 2019, and the reference is WITN 566-5004, he said this: "This was very disappointing, given that this problem predates devolution." And the letter of the 23rd of July gave reassurance that there would be consideration of an equitable share in funding to provide parity across the 4 UK support schemes. Jeremy Hunt, the now Chancellor of the Exchequer, stated that there should not have been a difference in payments across the United Kingdom, but that the UK government did not have the ability to impose a single scheme across the United Kingdom. It's our submission that he was mistaken in saying that. Even if the support schemes were a devolved matter, and you'll be delighted to know, so I'm not going to go into that thorny question, but even if they were a devolved matter, the UK government could seek consent of the devolved governments to establish a UK-wide scheme in 2 ways. Firstly, the ability of the UK Parliament to legislate in devolved areas is unfettered, although it would not normally do so without the consent of the Senedd. So that's all that's required, or the Scottish Parliament, or in relation to Northern Ireland. And that's, in respect of Wales, that's section 107, subsection 5 of the Government of Wales Act 2006. Secondly, the governments of Wales and Northern Ireland are able to delegate their functions to the UK government. And the power to do so is in section 83 of the Government of Wales Act 2006, section 93 of the Scotland Act 1998, and section 28 of the Northern Ireland Act 1998. Thus, our firm submission is that both the compensation framework and the continued support schemes should be established on a UK-wide basis. There is power to do so, even if it's a devolved matter. It would be for the 4 nations to decide whether it is in fact a devolved matter or not, and what budgetary consequences that has. It follows that we take issue with the submission made by David Johnson, King's Counsel, on behalf of the Scottish Government, that the support scheme should remain on a 4-nation basis, so as to retain flexibility to make different payments. That difference in treatment should never be allowed to happen again. And further, our clients from Northern Ireland are particularly concerned in relation to the continuation of a scheme in Northern Ireland because of the interruption to government there. So that concludes my submissions in relation to the first issue. Moving now to the second issue, which is the failure of the devolved health systems in Wales and Northern Ireland to achieve self-sufficiency. I wish to begin this segment with a quotation from the evidence of Professor Parapia to this inquiry. I will fairly read it out in summary form, as otherwise the transcript would be punctuated with questions. We say that this piece of evidence puts the decision-making of clinicians and regulators in context. And he said this: "When we went to conferences, meetings and so on, directors that were most closely associated with companies would stay in the conference hotels and have 5-star, etc. And you could see that there were gradations, and you could see that as you went lower down the usage of factor rate in numbers or type of centre, then you may have to go into 3-star or 4-star hotels, and you could see the dinners, etc. There was quite a big difference on hospitality that people got. The bigger centres were nearer working with pharmaceutical companies and so on. People who used more of the product had a lot of support for their departments, and there were individuals being employed as consultants. I know at least one who is still working as a consultant to one of the pharmaceutical companies. There were research grants. There was all sorts of available monies from pharmaceutical companies. It's unfortunate, because I think even now things haven't changed that much, although now they would have to declare it. And some things would be unacceptable now. If the gifts went above a certain level, it wouldn't be acceptable at all. But at that time, it was accepted practice. It was normal practice. Some of them were the same directors who were advising government. There were reference directors who were in committees that were recommending. I mean, we wanted honest advice, and it sort of made us think, is this purely unbiased or not? I think it was unbiased. I think we got very good guidelines from UK HCDO, but it wasn't pleasant visibly to see people not declaring their interest, which they would have to now. They wouldn't be allowed to do it. It would be scandalous. But at that time, it seemed acceptable practice to be a reference centre director, to be on committees that recommended the use of factor rate, and they would be the advisors to government. And these are people who are paid by the National Health Service, employed by the National Health Service. I felt sad for BPL that they were not able to compete on an equal footing with multinational companies. So, may I firstly deal with the attempts to achieve self-sufficiency, or rather, the adoption of the policy of self-sufficiency on a UK-wide basis, and I will do so at a pace, if I may. In March 1973, the Chief Medical Officer wrote to all senior medical officers stating that planning was required to achieve more domestic production of concentrate, to avoid very significant expenditure if amounts bought in excess of immediate needs. And that's DHSC 014005_033. Then in December 1974, Lord Owen, the Minister for Health, invested £500,000 in BPL and PFL. In March 1975, the following year, the regional transfusion directors were seeking to persuade clinicians to accept a steadily increasing supply of domestically produced concentrate. It was noted that regional transfusion directors did not always see eye to eye with haemophilia centre directors over the treatment of haemophiliacs, as HCDs wanted to implement home prophylaxis and treatment programs, whereas the present proposals were based upon home treatment when a bleed occurs. And so that the reference for that, sir, is LDOW 5018. And so it's clear that even as of 1975, the battle lines were drawn between the RTDs and the HCDs as to what self-sufficiency meant. Dr. Foster confirmed in his evidence that PFC could have fractionated plasma from England and Wales and could have fractionated around a third of the plasma from England and Wales. He disputed Dr. Lane's contention that the capacity of PFC was exaggerated. Dr. Robert Perry told the inquiry that there may have been some merit in a joint approach for the development, production and supply of plasma products on a UK-wide basis. In the event, BPL fractionated about 90% of plasma for the UK and PFC about 10%, whereas it should have been in the order of 50-50. Thus, in our submission, by the end of 1975, the position was, firstly, the DHSS had adopted a policy of self-sufficiency in concentrates based on the known risk of non-A, non-B transmission associated with imported concentrate. Secondly, the CMO had set up a working party to address the issue, and the DHSS had invested £500,000 in PFC and appreciated that the health economics indicated that it was financially prudent to invest more money in achieving self-sufficiency rather than purchasing expensive imports. Thirdly, the DHSS and the CMO appreciated that the freedom of clinicians to purchase imported concentrates for home treatment programs needed to be managed, whilst fractionation capacity at BPL was increased and arrangements with PFC were put in place, hence the reference to seeking to persuade clinicians to accept a gradually increasing amount. And then fourthly, notwithstanding that knowledge, no additional money was invested to achieve self-sufficiency, no arrangements were put in place at PFC, and no steps were taken to suppress the increasing demand by clinicians for imported concentrates. In January 1981, Mr. Meekins from the School of Pharmacy and Pharmacology at the University of Bath, wrote in the Times about the fact that PFC was not being used by the DHSS. That's CBLA 301229. He stated that the insufficiency of blood products in the UK was largely self-imposed by bureaucracy, and that because the health departments for England, Wales and Scotland are independent, blood is not sent north across the border. And he stated, "In my view, this state of affairs is nothing less than scandalous on the current efficiency situation, which is disadvantageous to both patients and the taxpayer." So the problem was there to be seen in 1981. Then in 1982, the DHSS decided to invest in BPL and to have PFC to focus on Scotland and Northern Ireland. And the reference for that is DHSC 301674. And of course, by then, Northern Ireland had entered into an agreement with the Scottish Home and Health Department for the fractionation of plasma from Northern Ireland, which I'll return to shortly, thereby entrenching the artificial division in fractionation to the disadvantage of patients. May I now move on to look at the devolution dimension in respect of self-sufficiency, but the UK-wide decisions provide the context. Now, in respect of Cardiff Regional Transfusion Centre, there is no evidence that any steps were taken by the Welsh office to enter into arrangements with PFC for the fractionation of Welsh blood to remove the expenditure of the Cardiff RTC on imported concentrate, and there is no evidence that the Chief Medical Officer for Wales took any steps to reduce the growing level of demand for imported concentrates. Dr. Tony Napier, the Regional Transfusion Director for Cardiff from 1977, agreed that it was open to him to take his own action, but that he tried to work with other RTDs. He stated that the issue of self-sufficiency was not a matter of great debate locally. He admitted that he was aware of the possibility of sending plasma to PFC, but that he didn't consider it. Had he been aware that there was a cap on the amount of Welsh plasma that BPL could fractionate, he would have considered sending plasma to PFC. Ultimately, he accepted that he did not discuss self-sufficiency with the Welsh office. He stated that had Cardiff RTC been resourced to produce the requisite amount of plasma, then it could have been self-sufficient, and in that event, it was likely that the worst of the HIV transmission could have been avoided in Wales, in South Wales, because South Wales was supplied by Cardiff. We are grateful to Council, to the inquiry, for their recent presentation on decision-making in Wales. What it demonstrates in our submission, in particular by reference to the evidence of Lord Barry Jones, who was Parliamentary Under Secretary of State in the Welsh Office between 1974 and 1979, is that, insofar as the DHSS took major responsibility, then the detail of blood products, haemophilia, other bleeding disorders, and hepatitis would have been within the purview of senior civil servants in Cardiff. However, he did not recollect making any decisions on blood policy. He also explained that it was a principal necessity for the Chief Medical Officer for Wales to inform either the Minister's officials or possibly the Minister directly about the risks associated with blood and blood products, and that the Chief Medical Officer certainly had responsibility for issuing guidance, advice, or instructions to clinicians. And I'll come shortly to a meeting with the Welsh Office and Professor Bloom where that didn't happen. But before I do, I'd like to turn to Northern Ireland. Dr. Maurice McClelland, the RTD for Belfast, consciously formulated a plan for self-sufficiency in relation to Factor VIII. He accepted that the purpose of the arrangements of PFC was to achieve self-sufficiency in Northern Ireland. The reference is RHSC 5076 at page 34. The Health Board, thus the Eastern Health and Social Services Board, became involved on the issue of self-sufficiency in blood products. He had regular meetings with Dr. Main because of the rising costs of concentrate. The Health Board wanted to understand how the costs may be contained, and they played a coordinating role between supply and demand. He tried to discourage Dr. Main from purchasing imported concentrates. He failed. An agreement in principle was reached with the Scottish National Blood Transfusion Centre in February 1981, that's CBLA 1388. But due to delays caused by the capacity of the Belfast RTC to carry out the required testing, the agreement was not implemented until April 1982. And that's CBLA 301572. Dr. McClelland wrote to Dr. Bridges in May 1984, NIBS 301719. In that letter, he stated that PFC was fractionating all the fresh frozen plasma sent by Northern Ireland so that they were self-sufficient in factor 8. It seems that the only product they were not self-sufficient in was albumin. The letter does note, however, that the demand at the Royal Victoria Hospital had doubled in 1983 from 1982. In evidence, Dr. McClelland confirmed that they were not using 100% PFC factor 8 because demand was increasing rapidly. Thus, in distinction to the position in Cardiff RTC, the story of Belfast RTC is that they did have an RTD and a health board with the foresight and desire to achieve self-sufficiency in 1981, but the plan was poorly executed in two ways. Firstly, a lack of investment meant that Belfast RTC could not carry out the required screening, which delayed the implementation of the agreement, and secondly, no adequate control was exerted over Dr. Main's purchase of increasing amounts of commercial concentrate, because, as explained by Dr. McClelland, blood products were procured and supplied directly to the haemophilia centre, but the cost came out of the NIBTS budget. We are also grateful to Council to the inquiry for the recent presentation on decision-making in Northern Ireland. It demonstrates in our submission that Sir Richard Needham, the Health Minister with responsibility for blood from 1985 until 1989, had no recollection of dealing with blood during his time as Health Minister. He blamed this on the Troubles and his far-reaching portfolio. Lord King, who was the Secretary of State for Northern Ireland, also denied any recollection of dealing with blood. The gist of their evidence is that Northern Ireland followed the policy lead of the UK government on health. However, that is problematic because we know that the Department of Health and Social Services in Northern Ireland reached an agreement to send plasma to Scotland for fractionation, and that the fact that the department was involved is shown by CBLA 301388. It may have been the position that Dr. Main was the main protagonist and that the Health Board played a coordinating role, but the department was involved. That was not following the policy lead of the UK government. At paragraph 17, subparagraph B of the presentation, it refers to Jack Scott not being altogether happy at Dr. Main's treatment policy in relation to SMBTS factor 8. He wasn't happy that it was being given preferentially to those already on treatment with it, with the rest being treated by commercial concentrate. However, it does not seem from the available material that Mr. Scott ever acted upon his displeasure at Dr. Main continuing to use commercial concentrate. Lord John Patton, the Parliamentary Under-Secretary in Northern Ireland Office between January 1981 and June 1983, told the inquiry that when he was in Northern Ireland, at a crucial time for the purposes of this inquiry, he did not recall seeing a single submission on blood and blood products, even though he was responsible for health and social services. Thus, the evidence in Northern Ireland seems to be that those with responsibility for decision-making didn't make any decisions, save to the extent that the agreement was reached with Scotland. There was nobody providing direction at a crucial time in Northern Ireland. So may I make a brief comment on an element contained in the oral submissions of Mr. Aldworth, King's Counsel, to the effect that the document retrieval exercise in Northern Ireland had been, in his words, successful. We say that's a rather odd way of putting it. There is still a marked dearth of evidence in relation to Northern Ireland. As the concluding remarks of the Counsel to the inquiry's presentation allude to. The remark that no evidence of document destruction had been found also faces the difficulty that any evidence of ill-motivated document destruction is also likely to have been destroyed. There was a meeting between the DHSS, the Scottish Home and Health Department, the Welsh Office and the Northern Ireland Office to discuss self-sufficiency in February 1981, and that's DHSC 5064. I won't bring it on the screen for reasons of time, and I will summarise it. It was agreed that although BPL were currently supplying England, Wales and Northern Ireland, PFC could play a role in meeting the needs of the United Kingdom. It was identified that PFC had the potential to meet around 50% of the UK's requirements for blood products. At paragraph 11, it was suggested that BPL fractionated Welsh plasma and would presumably continue to do so. So it was not revisited, it was presumed that that arrangement would continue. It may be appropriate for the Welsh Office to contribute towards the redevelopment of BPL, and similarly, if PFC fractionated Northern Ireland plasma, it may be appropriate for the Northern Ireland Office to contribute towards the costs of running PFC. Thus, in our submission, the possibility of different countries having their plasma fractionated at either BPL or PFC was expressly considered at this meeting. But what does not appear to have been considered on any evidence available to this inquiry is the possibility of Welsh plasma being fractionated at PFC at any point up until BPL was finally redeveloped in the late 1980s, by which point it was too late to mitigate the effects of HIV or hepatitis C on haemophiliacs in Wales. In terms of the UK government's attitude towards the NHS in Wales and Northern Ireland, Lord Kenneth Clarke told the inquiry he did not remember any meetings with the Welsh Office or the Northern Ireland Office. David Mellor told the inquiry that there was no time to discuss decisions with his counterparts in the four nations, and liaison was left to permanent secretaries and civil servants. Dr. Raymond stated that he did not have regular meetings with officials from the four nations, and that was normally left to administrators. He said that the exchange of information was also done by the administrators. He confirmed that there was no system or process in place by which medical advice was shared across the four nations. Often it occurred to the DHS late to notify the four nations of developments. He confirmed that the health departments of the four nations were smaller, so that the medical officers in those departments had a much wider role than haematology, so that they relied on the work done by the DHSS, and the policy decisions would come from the DHSS. In our submission, there are three problems with that evidence. Firstly, the exchange of information could only be done on the administrative side in respect of matters with which this inquiry is concerned if the medical officers told the administrators what information to exchange. Secondly, it can be seen from the limited documents available in respect of the Welsh Office and the Northern Ireland Office that they did not take policy instruction from Whitehall, but made their own policy decisions, which would be unreasonable if not based on all relevant information. And that was dependent on the medical officers in the UK government sharing all relevant information with the medical officers in the Wales Office and the Northern Ireland Office. Thirdly, the safe production of blood products in the UK is something that should have been considered on a four nations basis, given that the Wales Office, the Northern Ireland Office, and the Secretary of State for the Home Department, the Scottish Home and Health Department, were responsible for blood in their respective countries. So what you effectively had was an administrative devolution of the responsibility for policy making and implementation, but an over-reliance on information being given by the medical officers in the UK government, but then the medical officers, on Dr. Raymond's evidence, were not meeting regularly with the medical officers in Scotland, Wales and Northern Ireland. So the system was topsy-turvy. Rather, it seems to be the position that it was assumed that the Welsh Office and the Northern Ireland Office would follow suit. But that was inappropriate because they had the advantages of being smaller and the self-sufficiency being a more realistic prospect. Indeed, Northern Ireland did not follow England's lead and decided to pursue a policy of self-sufficiency of its own. In Wales, the issue was simply not addressed by those with the power to take decisions and the responsibility to do so. The Public Health Administration Expert Group made it clear that the Secretary of State for Health and Social Services was not responsible for health in Wales, Northern Ireland or Scotland. They identified a complication in that Wales and England were integrated for the purpose of some legislation and high-level policy. They commented that the lack of documentation in relation to decisions being made in Wales and Northern Ireland on blood policy may be attributable to the fact that the Secretary of State for Wales and the Secretary of State for Northern Ireland were not dedicated to health, but had a wider policy portfolio. They were unsurprised by the evidence of the ministers in the Department of Health and Social Services that they had little dialogue with their counterparts in the four nations, as this was a reflection of the Anglo-centric approach of the Department of Health and Social Services. They identified that the missed opportunity was not creating a national blood transfusion service that made the most of both BPL and PFC. The devolution problem, it seems, compounded matters, as there was a failure to recognise that there were different systems in place. I move now to address the exponential increase in the use of imported concentrates and how this impacted upon the policy of self-sufficiency. Sir, I note the time, it's 3:15. Would you like to take a break, or would you like me to continue?
Well, how much longer do you have to go, do you reckon?
So that rather depends on how much longer you're willing to give me.
Well, being as short as you can reasonably be, within your allotted time span, you mustn't take a disproportionate amount of time compared to others. How much longer do you think it might be? Otherwise, we'll take a break now.
So, yes, I would ask for at least another 30 minutes.
Well, let's take a break now, shall we?
Thank you, sir.
Come back at 4:45.